India's new criminal laws are taking into effect from today, replacing the decades-old Indian Penal Code, Indian Evidence Act, and the Code of Criminal Procedure. What do these laws mean for India? Will they help our citizens? To talk about this, I have with me Advocate Geeta, Luthra, and my colleague, legal editor Ashok Bagariya. Welcome to the News9 Plus show. Ashok, I want to start by asking you this. What changes to your mind are the biggest in the BNS, starting from today?
Well, there are a few changes which have been effected by the government of India. Now, there are basically 3 criminal laws which have been adopted and implemented to come into effect from 1st of July 2024, replacing these colonial era Indian Penal Code, Criminal Procedure Code and the Indian Evidence Act. Now, if you look at the Indian Penal Code, it was enacted sometime in 1832 and adopted in 1860. But strangely, from 1860 to 2024, this penal code has remained unchanged. And this despite the fact that India got independence in 1947, nothing was done to bring this penal code or penal laws in sync with the spirit of the Constitution of India. Now, the government of India has made an effort. It has enacted these 3 new laws saying that the Indian Penal Code, Evidence Act and the Procedure Code has to be replaced by these new laws which are more in sync with times and also accommodate the technological advances that we are witnessing around us. So now let's start with the Penal Code, now the BNS. The BNS, first thing what has happened is that it is a streamlined version of the Indian Penal Code. The Indian Penal Code had 511 sections. The BNS has 358. The second thing that the BNS does, to my mind, which is of very much importance, is the idea of community service which has been introduced. Now, the idea of community service as a punishment has been alien to the Indian laws. It's more to be seen that in the Western countries, the idea of community service as a punishment is there. But now what the BNS has done is that it has said that at least for 6 petty offences, community service as a mode of punishment should be prescribed. It has to be there. Now that is the first positive that I see. The second thing it does away with the differences in the age of minority across various provisions under the Indian Penal Code. There were some provisions under the Indian Penal Code which said that a minor would be a woman who is 15 years of age. Some others said a minor is a person who is below 18 years of age. Now BNS does is it wipes away this discrepancy in the ages of who a minor is, and it says that uniformly that anybody who is below 18 years is a minor. The third thing it says is that it does away with the most contentious sedition law. Sedition law has been under challenge in the Supreme Court. The Supreme Court had stepped in 2 years back and cautioned the government of India that if they don't do something about the sedition law, they might step in and also quash it as unconstitutional because it infringes with the freedom of speech of the citizens in this country. The other very interesting thing that has happened as far as these laws are concerned is the adoption of electronic evidence, in the sense now that a person who is to appear as a witness before the court does not have to physically go to the courtroom. He or she can record their evidence over video conferencing.
Absolutely. In fact, Ashok, there are a lot of good things about the BNS. I mean, the focus on forensics, the videography of stuff. It's clearly a set of laws that's meant for our times, and it takes stock of all the advances that have been made since the 19th century for sure.
Yeah.
But Advocate Luthra, do you think there was a lot of thought that's gone into this? Give us a sense of how long these changes had been in the pipeline for. And there's one school of thought that says that, look, these are sprung on the Indian people without adequate, consultation. The opposition has got its issues with this. But give us a sense of how long these laws have been in the pipeline. These new laws, the BNS, three of them.
So the first aspect is that there's always been a very long talk about a change in criminal jurisprudence and whether our criminal justice system was adequate or not. So this issue's been smoldering for a long time. I think we had the Prakash Singh committee which went into police reforms, and I think part of the criminal justice system which needs redressal and which I feel has not been redressed in the present three bill acts is the police reforms. Then came Malimat committee, and that again spoke of police reform, judicial reforms, and how to make the criminal justice system more answerable, how to make sure that the accused are convicted and the innocent do not, even if they get into the net, they are let off. And you've had a series of cases. So you remember, for example, the Arushi Talwar case.
Yes.
You'll remember Priyadarshini Mattu case. There are many cases. Now, Nirbhay's case. There was this whole aspect that we have to have more forensic evidence. We have to have more scientific tools. We have to maybe be able to detect from the teeth of a person, from the bone structure of a person, from the head of a person. You know how in that Indrani Mukherjee, where she was an accused in that the death of her daughter's case, all those cases, question is, how scientific can you make evidence? And I think it's equally important in rape cases, for example, or murder cases, residue in the nails, residue in the clothes getting caught, all those. Now, all that scientific evidence is hardly ever used in Indian cases. It was used in Nirbhay. Now, then we had a series of constitutional judgments. We had the striking down partially of 377 in the Suresh Kaushal matter. We had Joseph Shine, where 377. We had homosexuality, legalization, non-legalization. All these aspects went to constitutional courts or went to the courts. Issue of marital rape. Now, for example, it's not been introduced.
Yes.
But these were smoldering issues, and therefore some issue or not. Because what is all of law about, and this Lord Denning describes very beautifully, is a balance between the rights of a citizen and a human being and the rights of the community, and both the liberty of that individual versus law and order for the community. So that's what criminal law is about, the liberty of a person and the common law system, that even 199 guilty people should be let free, but one innocent man should not be convicted. Now that has been the common law ethos. And we can't call it colonial, we can't call it slavish. So there was need for changes. For example, 304A needed change. 377, the courts had interfered in cases of promise to marry as well as rape, which is non-knowing or stranger rape or rape by even a relative, but where there's no relationship. The police was crying also that let these be two different punishments for these. So there has been debate about it.
Right.
But the actual committee that sat on it was only about 2, 3, 4 years ago. I remember I was also consulted. Professor Ranveer Singh from NLIU was heading that committee. But I do feel that instead of, across the line making new enactments, ultimately as some people have said, it's old wine in new bottle. Most of the provisions are reiterated. Now, what is the need to change the name of the section? You know, you are right,
Yes.
electronic evidence. And this is not electronic evidence, which my colleague just said. It is, what he's saying is videography
Yes.
evidence through VC. Now, in criminal law, one of the most important things has been the demeanor of a person. The demeanor of a person is best seen physically. So while it should be permitted in exceptional cases that video recording should be resorted to, it can be resorted in civil cases, it can be resorted to in matrimonial or even arbitration, for example, cases where evidence is slightly more formal. I feel criminal law, this needs a lot of thinking, because ultimately you are going to convict a person.
Yes.
Sending a person in prison even for a minute is a blot on their life.
Absolutely.
And to make sure so there has been some thought of it. We can't say it's not been thought about. We can't say that there weren't many meetings with regard to this. But I still feel it was inadequate if what we had to do was an overall new changing of the laws. And remember this, that these laws, many of the old enactments were removed in the new India. But
Right.
these enactments continued. They've stood the test of time. They have been interpreted. Where 124A was being misused, it has been struck down. It was used in Gandhi's time. It was used in Tilak's time. Misused. It's been misused here in several cases like Vinayak's,
Yes.
in Kedarnath, all those. So, but the 124A has been introduced in another language. So while we've removed it, and while the Law Commission said it's probably required to remove it, the fact is that it has invidiously, by being said that it would be acts of treason against the state
Yes.
or acts. So it's come back in a different
I'm
manner.
going to Advocate Luthra, I'm just going to ask
Sorry.
Ashok this. Ashok, this is exactly the point that Advocate Luthra mentioned, the fact that it has crept in through other means into this new BNS, the sedition law, for instance. And is that one of the reasons the opposition is so opposed to this? Kapil Sibal, opposition MP, said that it was like using draconian police powers for political ends, and that's what he says these new set of laws are, come to represent. Do you believe that there is adequate justification in the fears that the opposition has put out, that misuse of this is very, very possible?
Well, the misuse of any law cannot be a ground of declaring it illegal or unconstitutional. Now, as Geeta ma'am pointed out rightly, with respect to the sedition law, while technically the government of India has removed sedition as an offence from the BNS, but has reintroduced another offence which is very similar to sedition in its spirit. So what was not permissible from the front door has made an entry from the back door. So there is justified criticism on this count that the government of India, while technically has removed sedition as an offence, it has reintroduced another provision of law which is very similar in spirit to sedition. Number one. Number two, as far as the criticism of these criminal laws is concerned, on the political level, the Congress party and the opposition parties have been saying that there has been no adequate discussion on the issue, because when these bills were introduced in the parliament, at least 142 MPs had been suspended and were denied an opportunity to participate in the discussion. And participation, debate, discussion is the lifeblood of any democracy. And if we do not have discussions on debates on new laws, the whole purpose of having a democratic form of government is defeated. So that is one criticism. On the legal side, as Geeta ma'am pointed out about the sedition law, there is another very draconian provision which allows the handcuffing of the accused. Now, this is a practice which was looked down on the Supreme Court of India, and it said that this practice of handcuffing or tying off accused in ropes is absolutely deplorable and against the human dignity of the accused, because at that point of time the person is just accused. He is not being convicted of an offense, and according to the criminal law, a person, even if he is accused, is presumed to be innocent till he is finally declared otherwise by a competent court of law. So this handcuffing provision is another very contentious provision which has crept in. There is another problem, is that a lot of legal experts have pointed out that there is inadequate definition of provisions which have been introduced in the BNS as well as the new Criminal Procedure Code, and which leaves a lot to be desired, and in fact leaves it to the discretion of the courts to interpret. Now again, if the court is going to interpret these provisions, it will have to fall back on the wisdom of their interpretation of the IPC and the CRPC. So what will really happen is that that understanding will get imported now. So in a way, when Geeta ma'am calls it an old wine in a new bottle, she is not entirely off the mark.
Right. Old wine in new bottle. And in fact, let's talk of the old bottle, that we were talking of, Ashok, earlier on in earlier show. Police reforms. Now, Mr. Prakash Singh retired as Director General of Police 30 years ago. He, that petition that he put before the Supreme Court, police reforms. His son retired as DG CRPF recently. That's 2 generations of police officers, and there's no sight. None of our police reforms are anywhere close to being realized. Do you think that, how critical are police reforms for all of these new laws to actually be effective?
Whether it's a new law or the old law, whether it was the Indian Penal Code or the BNS, we have to understand that the police or the investigating agency is the cutting edge, or they are the people who are responsible for implementing the law in the right spirit, or rather abusing the law as it exists. So until and unless there are reforms in the manner in which police work, not much is going to change on the ground, even if new laws are brought in place. Now, you rightly pointed about Prakash Singh, his son, who was also a IPS officer of the Rajasthan cadre and retired as DG CRPF.
Yes.
Prakash Singh has been fighting in the Supreme Court, or rather has been fighting a lot of battles in the Supreme Court, seeking a fixed tenure for police officers. So it was only on his efforts or a petition by him that we now have a fixed tenure for the Director General of Police in all states, and also that the appointment of the DGPs in the states is not made at the whims and fancies of the politicians, but in fact there is UPSC, the Union Public Service Commission, which recommends the fitness of a candidate to be appointed as a DGP. So in that sense, the process is a little fair, transparent and accountable. So those things have come, but a lot still needs to be desired.
Yes, lot still needs to be done. In fact, Advocate Luthra, the old bottle that we were discussing, which is the police reforms. What are the key police reforms to your mind that we actually need to implement to actually make these new laws effective? Because it's like the criminal justice system the police is very critical, if not the most critical. It's one of the most critical pillars of the criminal justice system. What are the kind of reform that you would see, that you would like to see in the police pillar for these laws to be effective?
So after Prakash Singh, the Malimat committee also made the same suggestion. Now, the fact is, one of them should be that we should have trained police.
Yes.
You can't have constables who are 10th pass, who are 12th pass, who are not trained at all, and you are asking them to handle very sensitive scientific. So you're really depending on them learning on the job. Now,
Yes.
you know, I remember making this comment about someone's after 10 years has turned out to be good. And I remember the person snubbing me and telling me that, you know, the person not supposed to be learning on the job. No person supposed to be a guinea pig. So people have to know their job when they join the police.
Yes.
People have to train before they join. And there has to be transparency. Powers of police have to be reduced. Here the powers of police are becoming more and more untrammeled.
Yes.
Even in today's day, police file status reports in courts.
Yes.
Why are they filing status reports? Why don't they file affidavits, which was the earlier practice? If you file an affidavit, you will be under oath that if you say something wrong, if you're filing a status report, what sanctity does that have? You're not liable for perjury. You made a misstatement, you're not liable. I mean, the court can take action. So what we wanted was more transparency, more effectiveness, more training, more scientific means, and this was suggested. So one of the aspects that has come in is you say that there should be CCTVs in police stations because women even today are scared to go to a police station. Women, we will always think twice before we send a woman lawyer saying, are you sure that you should go in at evening, even if your client is being kept illegally in custody? Now, these things should not be. So what you want is a more trained police. You want a more transparent police. We are not talking of IPS. Let's not talk of only the commissioner level, the deputy commissioner level, the IG level. We are talking of those who do the investigation. The constables, the head constables, the sub-inspectors, the inspectors. They are the police. They represent the police. They are the ones who do investigation. Should we have two wings? Should we have a trained investigation wing? You send the same man to be doing a motor accident case and
Yes.
taking a traffic challan. You send the same man to look at a murder case. You send the same man for a rape case. You send the same man on a crime scene and he comes 48 hours later, after which everything has been washed away and removed. And then you say, oh my God, this crime scene, there are no handprints, there are nothing. Handprints have been removed, everything has gone. Why should it not be scientific? Why should handprints, FSL, and today's day, you will notice that more and more cases are being resolved by WhatsApp messages, SMSs,
Yes.
telephone records, conspiracies are being proved by that. So you do need more scientific tools. That is what the amendment to the CRPC should have been. How do you, I mean, recently we were talking of a case where even though there is no primary evidence, based on a 65B certificate, you are doing a conviction or a trial. You can't do it.
Right.
Ultimately, primary evidence has to be there. You may keep it away. You may keep it in your locker. But you can't be truncating, saying primary destroyed. Now you go by secondary evidence because
Absolutely.
this is electronic.
Yes.
You-
Yes. Thank you very much, Advocate Luthra. We are completely out of time, I'm
Sorry.
afraid, but thanks
Sorry. Yes.
for your thoughts there. India's controversial new laws, Ashok. The laws have been amended, but the implementing agency, that is the police force, that is yet to be done. It's work in progress. We need more trained policemen. We need a transparent police force. We need a police force that steps ahead, is in step with the times. That unfortunately has not happened India's police reforms are something that have been in the pipeline for decades. Still lots of work to be done. But thank you very much, Advocate Luthra, my colleague Ashok Bagariya, for joining us this evening as we talk about India's new controversial laws that come into effect from today, the 1st of July.